Welcome to the presentation on navigating Florida's post-HB 837 personal injury landscape, where timing and thresholds now control outcomes more than ever. In the next few minutes, we'll unpack how new statutory limits, insurer tactics, and tightened damage rules compress opportunity windows, and we'll outline practical steps claimants and counsel can take to protect recovery under this new two-year regime. Florida's paradigm shift is stark. The statute of limitations has been cut from 4 years to two. Comparative negligence now zeroes out recovery at 51% fault, and medical damages are limited to amounts actually paid rather than billed. These changes mean cases must be evaluated and advanced faster, with fewer assumptions about full recovery or jury visibility of billed costs. Think of the new landscape as a legal clinical pincer squeezing case value between medical timing and statutory deadlines. On one side, you have medical reality, waiting for maximum medical improvement, and on the other, you have legal reality, the accelerated evidence decay, and a two-year statute that forces earlier choices. The smart strategy finds the narrow optimal settlement window between those forces. The 14-day PIP funnel is a hard deadline that often decides access to full PIP benefits. If an emergency medical condition is documented within that two-week window, the claimant can trigger broader PIP coverage up to policy limits, miss it, and benefits collapse to a much smaller cap or vanish entirely. That early medical evaluation is therefore mission critical to preserve both care and leverage. Florida's no-fault system also locks pain and suffering behind specific statutory keys: significant permanent loss of an important body function, a permanent injury with reasonable probability, significant scarring or disfigurement, or death. You only need to prove one, but proving it requires timely medical evidence and clear documentation to unlock non-PIP damages. Under the modified comparative negligence rule, shifting just past the 51% line wipes out a claim entirely, and insurers actively pursue fault-shifting strategies to reach that threshold. That makes immediate, rigorous accident investigation and fault documentation essential so insurers cannot manufacture or exaggerate plaintiff responsibility later in the case. Medical damages have been restructured. Juries aren't shown total billed amounts anymore, only what was actually paid to providers. At the same time, disclosure rules now force transparency about letters of protection and financial relationships. This changes valuation and negotiation dynamics, so tracking payments and documenting provider arrangements is now a practical necessity. HB 837 also created a 90-day safe harbor for insurers, a period in which they can tender limits with protection from bad faith claims. The effect is predictable: fishing expeditions, stalling, and pressure for early lowball settlements that test a claimant's financial endurance. Recognizing and resisting that pressure requires planning for litigation runway and alternate funding strategies. Understanding clinical timelines helps you pick the right settlement moment. Minor soft tissue injuries often resolve in days to weeks with low probability of permanent impairment. Fractures and orthopedic injuries commonly reach MMI around 6 to 12 months with moderate PIR likelihood. Spinal disc injuries often take 6 to 18 months and carry high PIR risk, while catastrophic injuries may extend beyond 2 years. The activation curve shows the trade-off between settling too early and waiting too late. Value is low and speculative at the start, rises as MMI and permanent impairment ratings emerge, and then crashes against the 2-year statutory wall. The goal is to hit MMI and secure a PIR while leaving enough runway to litigate if insurers stall, then file well before the statute expires. Tactically, this era demands 3 parallel priorities: secure a qualified medical evaluation within the critical early window to preserve PIP and initial leverage, immediately deploy accident investigation and expert evidence to prevent insurers from shifting fault past 51%, and pace settlements to avoid the 90-day safe harbor while aiming to reach MMI and a serious injury gateway well before the 2-year deadline.